suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is a Melbourne solicitor here to answer your legal questions on 1300 222 774. Do you have homework, David?
No.
No homework? Okay.
No. Christmas Eve was the last time, and I've had nothing since then.
Justin, clean the deck for you.
Yes, absolutely. That's what you do.
What would be the... I mean, I realise this is an unfolding situation with a house rolling down a hill, but any observations on who ends up paying for what?
Well, I suppose my question would be who's reported what to whom. So I can think the Victorian Building Commission and our council would be might be people who'd have some information. I suppose I would be if I was either the house below or the house. My question would be, what caused it? Was it a building problem? I would have thought. I imagine that we're talking about that Anthony's Nose, which is the very narrow point between Germana and Macrae, and I'd be wondering, what about groundwater? Is there a drainage issue which has caused the... And remember, we had an inch of water on Saturday.
Oh, yes, Sunday.
Sunday, yeah. It was 31 mil at the Australian Open. So I don't know what it was down there, but does that have time to get away, and does that weaken the structure? And yes, and I think there'll be lots of insurance companies wondering what their interest is in this property.
I think there will be. We'll leave that because that is still unfolding. If you're down that way or you know anything, happy to try and vet your details and get them to air. Rosemary is calling, though, from Ormond with a question for David Whiting. Rosemary, good morning. Go for it.
Good morning. Thanks for taking my call. I'm calling about a block of units consisting of 8 apartments. 2 on the ground floor at the front have private gardens. Recently, an engineer's report, they also have the front fence. An engineer's report was requested because we noted damage to the front at the fence, to the rendering and the bricks.
Yes.
And the engineer said that there was an invasive vine in the front garden of one of these private gardens in the unit that had caused the damage to the degree that it basically strangled the bricks. They're all cracked and it's rendered...
Yeah, it's getting in the mortar and it's forcing the bricks apart. Yep, understand the problem.
That's correct.
Yes.
That's right. And the builder and the engineer have both said that it's dangerous. The engineer said that it should be taken care of immediately because it's a dangerous...
Well, the question, you mean what, to people or to the structure of the building or what?
No, because it's on directly onto the footpath. So it's in danger of collapsing. It's only the vines that are holding it intact.
There are provisions in the Owners Corporation Act that give the Owners Corporation ability to act. The bit that I don't understand, and I wouldn't be able to understand without a copy of the plan of subdivision, is whether they are private gardens in the plan of subdivision or it's just because the way the building is located, they're simply occupied by the people who own the front.
No. Well, sorry to interrupt you. The gardens are on title of each apartment.
Okay.
But the management company employed to act on behalf of the Owners Corporation has come back and said that because on the plan of subdivision that the boundaries are median boundaries, they say that the owner of the garden with the vine that's caused the damage pays 25%. The owner of the adjacent apartment with private garden has to pay 25%, and all other owners must pay the residual 50%. Despite the damage being caused by the vine.
I would disagree with them, Rosemary. I would be coming along and saying that the repair work is unplanned repair work. It's not built into your maintenance plan, and that the work is being undertaken principally for the benefit of the 2 units at the front. I say they pay.
Thank you very, very much. I really appreciate that.
Okay. Thank you, Rosemary.
Good luck, Rosemary. That'll be interesting. I want to know how that one turns out. Tony's in Paran. Tony, what's your question?
Hello. In September, I looked through my security camera to find an MBN on the facade of my property. I didn't know what it was about. They removed a cable that ran from a 2-metre high conduit across the top of my roof. It's a Victorian joined terrace.
Yes.
But they installed fibre optic cable through that bit of conduit and then added ugly white conduit drilling into my facade to service the neighbour's property.
Yes.
So they said it's because it's a shared service, I've got no right. So I reminded them.
Why is it a shared service, Tony?
Well,
why aren't you independently connected to the system?
Well, I am, but there are 3 conduits on the front of my property. I thought all 3 were servicing mine, but it turns out that one of them was servicing the neighbours. So when they've upgraded to fibre optic, they've rerouted the part of the pathway across it's a very short distance, but still.
And do you want them to remove it, or you want them to pay you? What's your
I want to remove it. And the Ombudsman said, look, it doesn't cause enough damage for compensation. I said, I don't want compensation. I just don't want anything there it's got nothing to do with
Tony,
my
can I take that on notice? My question is really whether your claim is against the property owner next door who's receiving the service or against NBM who has installed the service.
Okay, didn't even think of the owners.
It's in a sense it's a service that he's requested. It's been brought in across your property. Can you make your neighbour move? It is my first question.
So you're going to look that one up for
that's
homework?
a homework point.
Thank you very much.
Listen, next week, Tony. Thank you. Bob is in South Caulfield. There are a few phone lines free, by the way, which doesn't happen very often. 1300 222 774. So if you've got a question for David, like Bob does, give us a call now. Bob, go for it.
Hi, we bought an apartment in off-the-plan apartment, and the building had a car stacker, which we didn't want, but the agent offered, if we paid quite a lot extra, an on-the-ground level car park.
You could have 2 parking spots rather than 1, or a double depth one, or what?
No, we were entitled to 1, but it was going to be on the ground level rather than down in the basement in the stacker.
Yes. Okay.
At a significant extra cost.
Right, and what did the contract say?
The contract had handwritten clauses which said that we were entitled to a ground level car park. On grade was the term.
Yes.
And it also had a clause saying that we weren't going to be liable for any of the maintenance or running expenses for the stacker.
Yes.
3 years later...
so you bought. Have you got your car park?
We got the car park just by sort of some friendly agreement, but we are getting charges for OC2, which is expenses to do with the stacker, and even call-outs when somebody does something stupid.
I'd be suggesting, Bob, that the basement car park where the stacker is has you as a member of the owners' corporation. Is that right? See, OC1 will own the building and all of the residual land, and OC2 probably is the car park?
OC2 is the stacker itself, yes.
Just one stacker for OC2?
Well, yeah.
So how many cars in the development?
To do with the stacker.
How many units in the development?
20.
So there'll be more than one stacker then, is that right?
No, there's one big stacker for the...
scary.
18, I think, are in the stacker.
And you want to stop paying the charges?
We want to stop paying the charges.
Then what you need to do, it requires an amendment to the plan, and you were looking to be removed from Owners Corporation 2.
Exactly, and we put that to the Owners Corporation the management company don't want anything to do with it. They say you've got a title that says you're in the stacker, and that's that.
Yeah, I accept that. You've got an action against your vendor for failing to deliver what he promised to deliver. But the end point you want to get to is an amendment to the plan of subdivision to remove you from Owners Corporation 2 unless there is something else in the plan of subdivision where removing you from Owners Corporation 2 isn't in your best interest. So, but that is an application under Section 32 of the Subdivision Act to amend the plan of subdivision.
So where does he go to? What is the first step?
Well, he's going to need to get a resolution from the Owners Corporation agreeing to him, to what he's doing. Then it requires amendment of the plan, council permission, land registry, consent of owners, monstrous. Go back and have a talk to the person who did the development, Bob, and see whether they will give you some compensation. but they're probably broke. Right? I mean, the answer will be that the companies...
They might still be in existence.
Yeah, then go and have a talk to them. But ultimately, you want to cease to be a member of OC2.
Well, that's exactly right. If they are resistant to or taking any action along those lines, is it a VCAT? Can you go to VCAT for enforcement of the
You can, if there's a dispute between you and the owners' corporation, you can take it to VCAT under the owners' corporation list.
Okay.
All right.
Good luck, Bob. Try the vendor.
Try the vendor first.
Potentially VCAT and the owners' corporation list. Does not sound simple though, Bob. So good luck. I'll get back to more of your calls with David Whiting in just a moment. Adam is in Kyabram. Adam, what's your question?
A quick question. So, long story short, I hurt my back, did a work cover claim, got covered for 8 months about 3 years ago. And now down the track, I've sort of developed acute arthritis. So I'm just curious in the back. So I'm just curious if I can go back through work cover or...
You can go back, but you've got a cause and effect issue. You're going to need to establish that the arthritis arose as a consequence of.
Okay.
Right? I've got an injury. I've got a problem in the same place. Doesn't automatically mean that I've got a problem with the same causation.
Oh, okay. So you'd have to prove that through physio and specialists. I'm
yes.
guessing.
Yeah, you would. Yep.
And the second part of that is the same employee. I had a COVID reaction and got a payout through the government. Am I able to go through the courts and get a payout through the employee as well? If that makes sense.
Do you mean the person you worked for, or someone who worked for you?
Yeah. So I got a payout through the government for a reaction, and I'm just curious if I can go through and also
and sue the person you worked for.
Yes. Yeah.
But what did they do wrong?
So they forced the third vaccine. So I'm just curious if they're liable for lost employment.
No. The answer to that would be no, because all of the conventional wisdom at the time was that it was necessary. And nobody forced you to go to work. Yes, it was a requirement that if you were going to work on site, that you had the vaccine.
Yeah. Well,
Now, you know, one in whatever it is will have a negative reaction to the vaccine. I don't say that I would have said, based on all of the knowledge that was then available, the requirement for a vaccine would have been considered to be a reasonable requirement. But nobody forced you to go to work.
So I'm not liable for like the 10, 20,000 I lost.
I don't know what you're saying the employer did wrong. You're saying that
I thought it would be under like the duty of care, but I'm guessing not.
No, there is a duty of care, but the duty of care is dependent upon knowledge and reasonable inquiry.
Yep.
So I'm saying that at that time it would have been a reasonable expectation from an employer to require you to take the vaccine for your own benefit and for the benefit of the other people you were working with.
Okay, Adam, good luck. Two queries there, hopefully giving you some form of answer there. Donna is in Heathmont. Donna, what's your question?
My question is that I have, I'm in a body corporate and our next door neighbour has planted the biggest conifer of all time.
Is this within the body corporate or next door?
It's next door.
Okay, yep.
And what's happening is that the roots are now encroaching into our property, and the sheer girth of the tree is now covering our clothesline entirely.
Yes, you do have an action against your neighbour, right?
Right.
And it is your neighbour's theoretical obligation, at least, to keep the tree entirely on your neighbour's property, both above ground and below. So there is an action for ongoing trespass, yes.
Okay, so how do I go about doing
it's a
that?
Magistrates court proceeding.
Okay.
And what you're trying to do is prevent a continuing nuisance. So, and if you like, it's trespass by his tree. Shouldn't be there.
Wow. Oh, okay.
Right. Now, I understand that the law was written at a time when people either had no rights or had larger properties, And so, but the expectation is you keep your property inside your property.
Lovely. Okay, so magistrates.
Magistrates court, yep.
Okay. Good luck, Donna.
Appreciate it. Thank you very much.
And Alex is calling from Ballarat. Alex, what's your question?
Good morning, Raf. I've recently purchased a property and it's due to settle in the coming weeks. We actually got early access to the property at Christmas time, and on Sunday with the heavy downpours, we've discovered that there's an issue with the box gutter that runs through the master bedroom, ensuite and walk-in robe.
Yes.
And it's leaked
How
fairly
old is the
heavily
house, Alex?
Sunday. It's an old church that's about 100 years old, but it was renovated about 7 or 8 years ago.
Right.
So relatively modern.
Alex, the problem is that there is no expectation that your box guttering would cope with absolutely extraordinary rain, wouldn't cope with a biblical flood, right? So the question is, if there's a provision in the Sale of Land Act at Section 12 that says, what would you have liked to have known about the property when you bought it? If so, tell the purchaser. Right? Now, if in the time that your vendors had been in the property, if they hadn't had the problem, then there's nothing to report to you.
We can see that there's evidence of it having leaked before. So now that you look at it and you've seen where the leak is evident on Sunday.
We then get to the question as to whether it was material. Would you have not bought the property if you'd known about the flood? And I say that, Alex, because I've got an office in a city building, and I got to work yesterday morning and I found that some ceiling tiles in a meeting room had fallen because there's water damage.
Yes.
Now, I've been in that building 8 years. There has never been any water damage. So, some things are just exceptional, and if it's truly exceptional, you have no claim.
So the fact that we haven't settled doesn't make a difference, David?
No, it makes a difference. It doesn't make a difference to your rights. It makes a difference to what you can do. Now, you're in a position to come along and say, that's a material issue, you should have told me. So, yes. But where do you want to go from there? Do you want to avoid the contract, or do you want compensation, or do you want it fixed?
Fixed, basically fixed.
Yeah, I'd be going along and saying, is it capable of being fixed? Is the box gutter, if it's happened before last Sunday, is it ever going to get to the point where you're going to get perfection?
Yep.
Or it might be but it would also be, I'd suggest, a claim on their insurer.
Yes.
Because they've got an obligation to deliver the property to you in the condition that it was when you when you signed the contract.
Okay. Now, so the fact you get early possession, that doesn't change?
It depends upon the terms of the early possession.
Yep.
Now, if the agreement says that early possession means you're accepting the contract as it is on the day of possession, and I think it's the Section 34 of the standard contract says something like you've got to deliver the property to the purchaser in the condition it was when inspected, fair wear and tear accepted. I don't know whether your early possession deal changed that. Because if I was the vendor and I was letting you in early, I would get you to sign an agreement that says, on the day I give you the keys and you walk in the door, that's it.
It's yours.
I have no more obligation. Now, we haven't talked about what you signed, just that you got possession. I think that would be relevant. Go back to your lawyer or conveyancer. But in the absence of anything else, your starting proposition is they have an obligation to deliver the property at settlement in the condition it was when you inspected.
Okay.
Yep.
Thanks very much for your time.
Good luck, Alex. And Diane is in Box Hill. Last call for the morning on the legal talk back. What's your question, Diane?
Hi. Thanks for taking my call. I have a question in relation to my mum's estate. My mum passed away about 6 months ago. And I'm the sole executor of her estate. At the house, my sister and her family have been living there for 10 years, rent-free. They're still there. My question is, given that we're both beneficiaries of Mum's will, what are my obligations in terms of negotiating with her? Do I need to...
So who's the executor, your brother or sister?
I am.
You're the sole executor?
I am, yes.
And your mum has died and you're allowing one of your siblings to live in the house?
She's been living there for 10 years already.
Right, but she
rent-free
was living
with my
there with
mother.
your mother's consent, wasn't she?
At the time, that's right, yes.
Right, and how long since your mum died?
6 months now.
Right, well, and you've got a grant of probate?
Yes, I have.
Then what you would normally do is negotiate that sibling's departure so the property can be prepared for sale.
Right, okay.
Hmm?
So I don't need to negotiate with her if she's interested in buying the property, which is what she said. But
You don't need to. It's really a question, and the two of you are the sole beneficiary, but between you, the only beneficiaries?
no, there's also grandchildren involved. There's 5
And
grandchildren.
how old are they?
So everyone is over 18 except
Okay.
for one.
Then, and how far away from 18 is grandchild number 5?
3 years.
Okay, right. You've got an issue in that you need to be mindful of the rights of the grandchild. Because your sister is not an executor, she is able to buy the property. So why would you not put in place a process that, if you couldn't reach a deal with her, say that the property is to go for sale by auction, but she is allowed to buy the property and she's allowed to use her share of the proceeds to settle the purchase.
Right.
Right, so sorry.
Sorry, go on.
So I'm suggesting is, yes, here's the deal. The property's to be sold. You're welcome to buy it, but I'm an executor. I've got an obligation to all beneficiaries, the 6 other
So
beneficiaries.
she'll need finance. You've got to basically go to her and say you'll need finance because
And
there
you'll
are
need
other
finance.
beneficiaries.
But the next question, Raf, is that at settlement, is she going to be able to use her share of the residue of the estate to complete the purchase? And Diane will make her a keener bidder if she knows that she only needs to come up with the difference at settlement.
Yeah.
Okay.
Okay.
So essentially, I do need to ask her if she's got interest in the property still, and then if she does, she can sort out her finances, is that right? Or,
Well, the property, I'd be starting with the property needs to be sold. No difficulty if you buy the property, but I would feel more comfortable if we went through the normal sale process and you were a bidder and you were able to use your share of the proceeds to complete the settlement.
Okay, Diane?
yeah, that's fine. Thank you.
Good
Thank you
luck.
so much.
Good luck. I hope that is resolved peacefully and briefly. All wills should be resolved peacefully. And briefly. David, thank you very much. You got one bit of homework there.
Indeed. Thank you, Raf.
David Whiting answering your questions every Tuesday.